Hi, I'm David, staff attorney at Neighbors Link Community Law Practice, talking to you today about whether you can get a green card if you have lived in the United States for 10 years. The so-called 10-year visa. Hypothetical. Rosalina walked across the southern border into the United States in April of 2000. She did not see any immigration officials and was not put into proceedings. Rosalina has never filed any petition or application with USCIS. In 2010, Rosalina married Bob, a United States citizen. They now have 2 children, both born in the United States. Rosalina hears about a lawyer who is filing 10-year visas, and because she has been here for more than 10 years, Rosalina makes an appointment. The lawyer wants $10,000 to work with Rosalina and tells her that he can get her a green card even though she entered the United States without inspection because she has lived in the United States for more than 10 years and has a United States citizen spouse, United States citizen children. The lawyer doesn't ask Rosalina any questions and says she should make an appointment when she has the money to pay him. Rosalina leaves the office confused but hopeful. She knows that she cannot adjust her status, which means get her green card, in the United States since she entered without inspection. She also knows that her spouse can file a petition for her, but she would have to return to her country to get a visa at the consulate, and that if she departs from the United States, she will be barred from coming back for 10 years. But this lawyer said that he can help. So should Rosalina borrow the money to pay the lawyer? What people casually call a 10-year visa is actually called cancellation of removal. Like the name says, a person applying for cancellation of removal must be in removal proceedings in order to ask the immigration judge to cancel the removal. Rosalina is not in removal proceedings and has lived a quiet life in the United States. Although undocumented, she has not had any issues from USCIS. So, if Rosalina agrees to this plan with the lawyer to file the asylum application with USCIS, with the hopes that USCIS will deny the application and refer Rosalina to the immigration judge where she can apply for cancellation removal. But wait, does Rosalina have an asylum claim? Has she ever been persecuted, or does she fear persecution in her country? If she does not have a claim, filing a frivolous asylum application shall render the respondent permanently ineligible for any benefit under INA, aside from withholding or removal. Since Rosalina does not have a viable asylum claim, this is a huge risk. Even if Rosalina files that asylum claim and it is denied without a finding that it was frivolous, does she want to be put in removal proceedings where she can be deported? Does Rosalina even have a claim for cancellation of removal? To qualify for cancellation under the Immigration and Nationality Act, Rosalina must have a spouse, parent, or child who is a United States citizen or a lawful permanent resident. Rosalina has 3 qualifying relatives, her husband and both of her children. But it isn't that simple. In addition to proving that she has been physically present in the United States continuously for 10 years and that she has good moral character, Rosalina must also prove to the immigration judge that deporting her would cause exceptional and extremely unusual hardship to her qualifying relative, her husband and children in this case. It's not enough to say that her family will miss her or even struggle if the judge deports her. It's also not good enough to say that your United States citizen children are young. Often the immigration judge reasons that you can take your children with you when you are deported, or that they can stay with their other parent. One type of hardship that usually makes a good case for cancellation is when a qualifying relative completely depends on the applicant because they are sick and the applicant is their sole caregiver. So this might work for Rosalina if her husband or one of her children is chronically ill or has special needs and Rosalina is the only person taking care of them. So, if anyone suggests you apply for a 10-year visa, think about whether you qualify for cancellation or removal, and think about whether you want to file an asylum application. As always, immigration law is complicated and depends on many factors. It's very important that you consult with an immigration lawyer before making any decisions, and if the lawyer you speak with isn't clear or doesn't respond to your questions, find another lawyer.